So welcome. This is the Food Well Alliance and the Law Farms Farm Law webinar series. I'm going to say that 3 times fast. And this webinar series is a partnership between Food Well Alliance and the Law Farm. It is made available due to the generous support and funding of Food Well Alliance. I will talk about how you can work with me one-on-one after this webinar, and the great pricing of those things is also a part of Food Well Alliance's support. This is the Conservation Tax Benefit webinar. We've already had a few webinars in the series on topics like local government and zoning, which I will mention in this webinar as well, and you may want to reference. And we've talked about intellectual property and a couple other topics already. The last 2 of the year, in November, we're going to be talking about employment issues. And in December, I'm going to use this hour and a half of time to go through a farm business from cradle to grave, from conception to secession, all of the T's to cross, I's to dot, and a big picture overview, especially since December, January, those are good times to kind of get the ducks in the row before the big growing season starts. Even though the more I think about it, there really isn't a good time to get the ducks in the row when you are running a farm, because all of those times are vital to keeping production going. But the rumor mill has it that December, January are good times for that. So come in December and we will talk from conception to secession. But tonight we are going back to conservation tax benefits. Oh, and more farmtrepreneur resources are available on Instagram. I forgot. We finally have a formal Instagram for the Law Farm. So if you want more of these resources, these topics, to see things about them, to hear a lawyer's perspective on farm businesses, check out at the.law.farm for more. And there are the dates for the employment and business webinars coming up. Okay, here we go. And of course, because I'm a lawyer, I come with a disclaimer. This presentation will not provide legal advice. This presentation will provide you with legal information and education. It will also guide you to transform dense law into clear action steps. And it's going to empower you to integrate legal tools into your farm business infrastructure. But there is no legal advice on this particular webinar. There will be no attorney-client relationship created in this webinar, and there is no confidentiality preserved with what you share. So when you do Q&A, if you have specific questions, keep them as high level as possible, maybe even hypothetical. And if you have those very individual nuanced questions, they're going to be perfect for office hours with me, one-on-one. And I say that a lot, that it's not legal advice, that it's legal education. And I want to go ahead and break down what that actually means in this context of conservation use benefits. Legal education is defining CUVA for you. What is CUVA? What does it mean? Legal education includes practical tips to consider when you're applying for CUVA, an overview of the penalty structure, that is just taking the statute and making it into a checklist. Those sorts of issues are legal education. Legal advice is determining if your property qualifies. So as soon as we start adding information that is particular to your case, and by case, I don't mean law case, I mean just your individual instance, that's getting into the legal advice territory. So creating an action plan for you and for your business is legal advice. For considering changing ownership or use of a property that's under CUVA, making those individual considerations all fall under that umbrella of legal advice. And then legal representation is one more step down that line, where that's actually having a lawyer show up and represent you in a formal proceeding, and a formal negotiation, and a formal appeal. So in the CUVA context, legal representation would be appealing a qualifying use determination by the tax assessor's board, and a lawyer actually showing up on your behalf, or writing those emails on your behalf, or sending those letters. Or educating assessors on agritourism. A lot of these sustainable farm issues have an education piece with the folks who are making decisions around them. And legal representation might look like an attorney stepping up and actually helping you with that education piece so you can keep farming. Or of course, appealing any breach penalties that might come up. That's in the legal representation realm. This webinar is definitely legal education. When we get together for office hours one-on-one, we're in that legal advice realm. And if you need legal representation, either myself or somebody else can be of service to you and to get that full representation if an issue comes up. I'm a huge proponent of doing everything you can to stay in the legal education and legal advice realm to prevent needing legal representation. That's my soapbox. So we'll move into talking about this CUVA conversation being a part of a bigger land ownership conversation in general. When it comes to being a farmtrepreneur and being a sustainable farmer, whether it's in the city or outside of the city, either one, having land is a huge asset for a farmer. And that includes everything from soil and remediation and having the right kind of soil to finding and acquiring land, to financing, to saving money wherever possible, be it tax benefits, just anywhere you can trim the fat off of the budget, you want to do it. It helps the business, helps the bottom line. And then keeping land. When you have land, how do you make sure that business is running the way it is to have an income that you need to keep that land? And of course, it all comes down to running a business. All of these aspects of land ownership are aspects where a lawyer can be involved as that legal advice piece or that consultation piece. And there are also other resources available to farmers in that realm. The Conservation Fund is doing great work to rescue, in a sense, farmland that may otherwise be leaving the farm realm. They're trying to buy up that property and make it more available to farmers with lease to purchase options and lower prices generally. So the Conservation Fund is a great resource. Federal farm loans are another resource that can be used to purchase land, to get that land. Of course, Georgia Organics, Food Well Alliance, the Law Farm, all of these are places that farmers can turn to have these questions asked about how do I own land and how do I keep it? And the Conservation Fund, federal farm loans, and even local programming, it's important to keep in mind that these entities do phenomenal things for farmers. They make great resources available, but they don't represent a farmer or a farm business. They represent their own enterprise. So keep in mind, even when you're dealing with somebody who has your best interest in mind and is created for you, always read the agreements. Check up on what you're doing and know that it fits your bigger vision to get involved. J.O. Lu, I see you have your hand raised. Do you have a question?
I do, and well, first off, I didn't remember. Did you say we can ask questions while you're going through it, or you wanted us to hold our questions until the end?
You can ask questions. Go ahead.
Okay, cool. Appreciate it. I was curious when you say federal farm loans. Can you give some examples of those federal farm loans that you're referring to?
Sure. The having a brain moment on the actual acronyms, but the federal government makes loans available for beginning farmers, for new farmers, for female farmers, and lots of different intersectional groups who are entering farming. They have loans available for those folks to get into it. There are loans that can help you acquire property. You can even use some of the federal farm loans as a down payment for a piece of land, for land ownership in the farm realm. And there are also some micro loans just for property, or not for property, let me not say property in this context, for machinery. So for a tractor or for a lettuce washer situation set up. There are all sorts of loans available through the federal government and the farmer services programs. Does that answer your question, J.O. Lu?
It does. Good, thanks.
Great. But let me drive home my point again. Thank you for the setup. A loan is a fantastic opportunity to get access to something that a farmer might not otherwise have. But understanding loan terms, understanding loan requirements, understanding The payback of a loan long-term is a great place to just stack the professionals that are behind you supporting you. Have a lawyer explain the terms to you, have an accountant sit down and actually explain the payback of that loan over time. You brought me to my next point very well, set me up. Thank you. Don't ignore the overwhelming parts of business. Those loans are exciting opportunities. They come with that knowledge that there will be a payback, that there will be interest due. Build a team to support you on those parts of your business that feel overwhelming. Don't ignore them. Don't just jump over them in a hurdle to just get the next thing and the next move. Understand what you're doing, feel confident in what you're doing, and build that team to support you. So tonight we're going to cover property tax benefits available for agriculture in Georgia. We're going to talk about the details of the CUVA agreement. I'll talk about what CUVA actually is. I will define that acronym. We'll talk about some CUVA housekeeping details, and then other property tax assessment issues in general. And this is using a Georgia case study. There's a rural farmer in Georgia. She falls under that farmtrepreneur umbrella of the folks I love to work with. And she's had some tax issues come up, and she has a firsthand experience that we had a conversation before this webinar, and she gave her takeaways for you guys and shared her story with permission for me to share it with you of just what some of these property tax issues look like when they play out and the personalities that may be involved. So I'm really grateful that she had that conversation and we have that experience now. Okay, there's a lot of words on here, but this slide is meant to break down different tax benefit distinctions, because some tax benefits that are available to farmers apply automatically. And that's those first two bullet points. And you'll notice in bold, it says it automatically applies. It may require action on your part just to keep up with it and to make sure that it's applying to your business. There may be no one who will alert you to it, but they automatically apply by statute. And this includes the produce sales tax exemption. If you're selling just produce, you don't need to be collecting sales tax on that, and you don't need to be paying it to the Department of Revenue. And the same for sales and use tax exemption for agricultural operations. There are certain things you as a farmer may not need to pay sales tax on. And again, that's just provided by statute. You'll need to know about those things, and you may need to remind somebody that they apply, but they apply by statute. Then you have some tax benefits, or you may gain a benefit just from appealing a tax assessment. The tax assessors that come up with the value of your property that then becomes how much tax you owe, you can hold them accountable. If you notice that something feels a little high and doesn't make sense, you can ask questions and you can appeal the value, and you might get a no, but you might not. And so these are the sorts of issues that involve noticing and taking action on tax assessments generally. And then that last group of tax benefits, these two are benefits that may apply, but they require an eligibility that's defined by statute and an application process. This is something that even though it may apply to your property, you have to take the affirmative step of reaching out and putting it under a conservation use valuation assessment or the agricultural preferential assessment. They involve talking to the tax assessor's board, getting that application, and actually signing a covenant with the assessor's board for it to apply, and that covenant runs with the land. And so the property tax benefits available for agriculture in Georgia, what are they? Let me back up a little bit and explain what ad valorem taxes are. And when I say property taxes, I'm talking about ad valorem taxes in this webinar, and I'm using them interchangeably. Often in conversation, when somebody's talking about their property and they're talking about their property taxes, they'll also use that phrase interchangeably interchangeably with ad valorem taxes. An ad valorem tax is a tax based on the assessed value of an item. So property taxes fall into this category. It's based on the assessed value of your real property, of your land. This is also the same tax that is applied to cars and boats. And that assessed value of, be it the real property, be it a boat, be it a car, the assessed value is used to calculate the tax that is owed to the tax body, to the tax assessors, to the Department of Revenue. The value is assessed by a local jurisdiction. Usually it's a county jurisdiction. Some of ad valorem taxes, actually I'm going to quit that sentence there. Usually it's county by county is how each of these properties are assessed. And then taxes are usually paid by landowners, but I put usually in italics because this is something that is a negotiation point in a lease. I could very easily see a lease be written that gives a farmer a much lower rent, but maybe they're held accountable for the taxes on that land since they're using it. And that may benefit in some cases to pay the taxes, but pay a lower rent. So taxes are usually paid by landowners, but a lease for a piece of property can change how that arrangement works and who is actually liable for that tax. So that's ad valorem taxes. I will put a little asterisk here and note that this is the tax that is applied to cars and boats. If I had a tractor, I am not a farmer. I am a lawyer who loves farmers, but I'm not a farmer. If I had a tractor, my tractor would be subject to ad valorem taxes. If you as a farmer have a tractor and you don't use it to go to work, it's just your tractor for your farm, that should not be taxed as property tax. So keep that in mind too. That your farm equipment does not fall under the same property tax purview as these other things. Okay, going back into property tax, real property, and the assessed value of that real property to pay. So the first tax benefit that I'm going to mention that applies to agriculture in Georgia is the agricultural preferential assessment. Now, and I think I defined CUVA, but I did it very quickly. It's the Conservation Use Valuation Assessment. Let me not just say that. Let me hear the words again. That last bullet on the slide, Conservation Use Valuation Assessment. Before CUVA, in drasticness, if you will, is the agricultural preferential treatment. This designation of agricultural property or of a piece of land that you might own, it will provide about a 25% savings on fair market value, but it's not going to give you the same stable, low tax assessment as CUVA will. This could be very variable. If fair market value changes drastically on your property, your tax assessment is also going to change drastically, and you can't depend on it staying as low as it would under CUVA. But a benefit of the agricultural preferential assessment is that it applies to up to $100,000 of agricultural production and storage structures. Now, for an urban farm that's already on small acreage and that may not have huge warehouses for production or storage, this may not be as applicable. But for rural properties, and as a farmer grows up and maybe moves out of the city limits, this could be a beneficial thing to think about. And it has a different penalty structure than CUVA. So I'm mentioning this in the beginning in a very colloquial, anecdotal way. I might call this CUVA light. And remember that you can get some tax benefit on the production and storage structures themselves with this agricultural preferential treatment. But the biggie, the one that most folks are talking about when they're talking about conservation use benefits, is conservation use value assessments. And this is instead of looking at a piece of property based on its fair market value or what it would sell for on the market, it's looking at the value of a piece of property in a conservation in the conservation state. So in addition to agriculture, which is included as a conservation use in Georgia, a conservation state could be wetlands or timberland, and there's could be some others on different levels, but there are different types of conservation assessments. Agriculture just happens to be one in Georgia and is a fantastic benefit for farmers to take advantage of. The state supports agricultural land remaining agricultural land rather than being turned into development. And I think that piece is very, very important for urban farmers and for metro farmers to keep in mind. If you have purchased land in the city, if you're a farmer, or if you have been involved in any way with those valuations to see those numbers, in the city of Atlanta or in these counties that are right outside of Atlanta, property values can skyrocket sometimes. And if you're farming, it has a very different value. You're not building condos, you're not building townhomes on that piece of property to make all that money back. You're growing food for your community, and that has implications. And CUVA honors that and recognizes that. So CUVA can apply to a maximum of 2,000 acres of property, not really relevant in the urban and suburban realm, but that is an important aspect to keep in mind for CUVA. Less than 10 acres of property can be under CUVA, but it requires proof of the conservation use. And that should be pretty straightforward for a farmer if you're farming an acre or 2 acres or 3 in the city. If you have a Schedule F or a Schedule E or any sorts of receipts of income that have to do with farming, that's the sort of proof that they need. So I say all that to say that CUVA can apply to any agricultural property in the state as long as it's being used for agriculture, and I'll go into more depth of what that means. But it can apply to even the half-acre farm if it makes sense, or it can apply to a 100-acre farm. This is an important note. Neither the preferential assessment, the CUVA light, if you will, nor CUVA apply to residence values and the property on which the resident sits. So if I have 5 acres of property and my house is on there as well, I can apply for CUVA for the entire property beyond my house and where my house sits. So it's not going to get me any benefit or any savings on my residence. And that's for both of them. That's for CUVA Light and for CUVA. That just what you're living in, you still have to pay the full tax on based on fair market value. So CUVA is saying, we realize that your property is not worth the same as the same acreage that would be sold to a developer who could then, build condos or townhomes and sell them off. So CUVA has actual value tables that are updated yearly, and they're decided in the rules and regulations of Georgia. If you want to access them at any given time, look at previous years, or in 2022, if you want to see the updates, you'll use this website right here, https://dor.georgia.gov/table/conservation-use-land-values. So that's going to bring you to this first picture on the left. This is exactly what you'll see when you log on there, with the table of conservation use land values. And then you'll click on the conservation use land values and you'll see the different years listed. And you just choose the year that you want to look at. And let's go ahead and look at just what that looks like in general. It's based on your soil reshare my screen. It's based on how good your soil is. If it's a phenomenal soil for growing crops, or if it's a not so great soil for growing crops, is going to decide what you pay. And this is what it looks like. It's a lot of words, actually, which is a little overwhelming. It's not set up as a table. But if we are talking about Fulton County, we would find it in the CUVA #2 counties. And then it'll have some W values and some A values. The W values are referring to timber, and the A values are referring to agriculture. And these numbers are the price per acre of these different agricultural designations. So for A1, which is like top-notch soil, this is soil that is fertile, it is ready to go, it's going to create great crops. That's going to be assessed at $1,850 per acre. If you have the worst soil that you can get on this designation table, it's going to be assessed at $759 per acre in Fulton County. If you have shopped for acreage in Fulton County, especially the city of Atlanta, you may find that properties can be close to $300,000 per acre or more. So this $1,800 and $759 per acre is a very big difference in doing that assessment of how much property tax you owe each year. So let me go back to my PowerPoint, and we are going to get into the numbers. You're welcome. And actually look at what that savings means. So we know that CUVA is just a different way of valuing property. That valuation is the assessment that is going to tell you how much tax you owe each year. So here's an example of CUVA savings. In a hypothetical, I wish I owned 5 acres of land in Fulton County, but I do not. But in this hypothetical, if I did, without CUVA, my land could easily be assessed at $100,000 per acre. If we were figuring out what tax I owed on that, we would multiply that number by 40% and then the 0.00933 millage rate. The 40% is a constant number. Your property value is always going to be multiplied by the 40% and then the millage rate. I highlighted the millage rate in red because that is something that also changes, just like the CUVA assessments change. The millage rate changes around for counties for different years. So that's another number you may want to look up if you're doing this calculation for your own property for yourself to make these decisions. So when I multiply $100,000 by 40% by that millage rate, I get $373.20 per acre is what I owe. So if I multiply that final number by all 5 of my acres, then my property tax that I would owe to the Department of Revenue would be $1,866 that year. Now with CUVA, let's say I have the A1 soil. I've got the best agricultural soil you can get. The base rate for that is $1,850 per acre instead of $100,000. So if I use the same calculations on that $1,850 per acre, I come up with $690 per acre is how much I owe. And then when I multiply that by my 5 acres, I would owe $34.52 per year with CUVA benefits. So the difference, the savings is $1,831 per year. So over the course of 5 years, that's $9,000. Over the course of the 10-year span of the CUVA covenant, That could be $18,000 that I save with CUVA savings. It's a big number. And if CUVA applies, that could be the difference of me feeling very confident in my retirement savings instead of having to pay those in taxes. That's $18,000 that can be applied in lots of different ways to invest in your business, to invest in yourself. But I keep mentioning, well, so this is the actual statute. Let me back up and say that thought though. I keep mentioning penalties of CUVA, and I'm going to go more in depth with them. CUVA has a good savings, but that savings is only good if you're sure this is a good fit and you're not changing anything on your property. So pin that. We're going to talk about the penalties. I'm going to talk about the dark side of it in just a minute, but I'll go ahead and do the quick rundown of the statute. The statute is in the Georgia Tax Code, which the first bullet there has OCGA, which is the official code of Georgia. That double S mark is the section, and then it's 48-5-7.1. That 48 is the tax code. So it's chapter 5 of the tax code, section 7.1 is where you can find all of the conservation use value assessment information. And if you were to just Google that OCGA section 48.5.7.1, it would likely bring up Justia as the first website available to you. And that is a resource that I use and that I trust for looking up statutes just at a glance, just to quickly look at it and see what's going on. It doesn't always pop up with the most recent version of a statute, so just keep that in mind. But you can Google statutes and you can find them in their entire written language if you ever have any questions or want to go more in depth with this stuff. So conservation use value assessment applies to tangible real property which is devoted to bona fide agricultural purposes. Land that's used for agricultural products, including horticulture, floriculture, forestry, dairy, livestock, poultry, apiarian products, and all other forms of farm products. It has a limited inclusion of storage and processing property, and that's actually just the preferential assessment. And then it excludes any residents on the property. And you must also be a qualified landowner to apply for CUVA. And this means if you're not the landowner, if you're leasing property, you can still go to your landowner and let them know about CUVA. There may be benefits for them getting that CUVA covenant and having those benefits, even with you leasing their land. But no matter if you're leasing or if you actually own it, the landowner that applies for CUVA benefits has to be one or more natural or naturalized citizen or a family farm corporation. And further in the statute, it says that that family farm corporation has to have a controlling interest between the family within the 4th degree. And then 80% of its gross income is made from bona fide agricultural purposes. So with CUVA, you have to have a piece of property. It has to be devoted to agriculture. And then to apply, you have to have that qualified landowner, either a person, an individual who is a citizen, or a family farm corporation that fits those qualifications. So just for CUVA in general, ask yourself, is the property being used for those bona fide agricultural purposes? Is the landowner an applicable owner? Is the landowner on board with the idea? A lot of farmers in the urban and metro area are leasing land. So can you get the landowner on board with the idea? And then what is the total savings? That calculation that I did on a few slides ago is important to do for your property. Figure out exactly the number that you're going to save or that you're likely to save for this year or the next year. It's not going to change drastically. It can't change more than 3% from year to year under CUVA. And it can't change more than 30% over the 10 years. So figuring out that number for this year gives you an idea of that savings over the 10 years. So you can start figuring out, does it actually make sense for your bottom line? And that goes to that last point. Does it provide a substantial savings? Maybe it does, maybe it doesn't. And so let's talk about the details of the CUVA agreement. And this includes some of the darker side, if you will, of what you are agreeing to when you put your land under conservation use. So as I said, who can apply as the landowner, which is one or more natural or naturalized citizens, or a family farm corporation. The landowner will apply through the county tax assessor's office. And I reiterate this, especially for those folks who are leasing property and want to put it under CUVA and want to have that discussion with the landowner. The landowner is still going to have to take the initiative to do these things. Unfortunately, if you have a kind of absentee landowner, which is lovely for some reasons, it's not when it comes to getting these CUVA benefits. They will have to apply themselves through the tax assessor's office, and they will be the ones to sign the covenant for the tax benefits. So again, this bona fide agricultural use keeps coming up. And I think it's really important to stress, because not everything that farm entrepreneurs may be doing on their property falls into the umbrella or falls under the umbrella of agricultural, bona fide agricultural use. So if you're raising, harvesting, or storing crops, that's totally a go. Feeding, breeding, or managing livestock or poultry, totally good to go. Producing plants, trees, fowl, or animals, or production of aquaculture, horticulture, floriculture, forestry, dairy, livestock, poultry, and apiarian products. Up to 50% of your land may lie dormant. You don't have to do anything on it. However, the unused portion may not be used for any other business use. And this is a 10-year covenant. When you apply for CUVA benefits, you're saying for 10 years, you will make a commitment to use the land for bona fide agricultural purposes. Like any good agreement, it spells out the consequences for breaching, and the penalties are steep. If you breach a CUVA covenant, you will pay 2 times the CUVA savings for each year up to the breach. And what would constitute a breach? Selling soda or hot chocolate at your agritourism operation. Hosting a farm wedding during the first year. You can host a farm wedding after the first year. That's in the statute. But if you host a farm wedding during year 1, that's a breach. Starting a soap business on a produce farm could constitute a breach. Or putting an RV on the property to rent out to visitors. I see the shock face come up, and yes. So some things that fall very much in line with the bottom line of lots of farm entrepreneur endeavors could be a breach to these CUVA benefits. And that's why I stress do the calculation, figure out exactly how much money you're going to save with CUVA, because if you're going to save $18,000, but you could make $30,000 in 1 year with your soap business, go for the soap and pay the full taxes. But really, this goes back to my major point of have a team to support you to think through these things. What is your bottom line? What is your mission? And does CUVA even apply? Is CUVA a great thing, or is CUVA going to hold you back from your incredibly entrepreneurial endeavors? So these are the sorts of things that constitute a breach. And I think that top one of selling sodas or hot chocolate at your agritourism operation is especially important to keep in mind. If you go grow Christmas trees and you're selling Christmas trees on your property and you invite people on your property to cut them down and buy them, you're totally covered by a CUVA. Like you can have that CUVA tax benefit and you can do that. The minute you sell hot chocolate while they're doing it, that's what constitutes a breach. So just knowing that, being equipped with that knowledge, empowered with what you can and can't do is so important, and make those decisions with full knowledge and disclosure. So we talked about the savings and we came to that $18,000 number. Now I want to show you the number if you breach CUVA. So this is the same 5 acres that I own in the hypothetical land that we started a little while ago. If I breach my covenant in year 6, and step away from the PowerPoint presentation for a second and just think about real life, 6 years. 6 years ago was 2015. We hadn't gone through a pandemic. Who knows what life changes you've had since then? Have you had kids? Have you gotten married? Have you moved around? 6 years is actually a long time. And if I breached my covenant in year 6 with the amount of savings I was getting, my penalty would be my savings per year for those 6 years times 2. So that was that 1,800 number times 2 times 6 would be $21,977.76 I would owe back to the Department of Revenue with interest. So if I can't pay that right away, I'm paying interest on that money as I'm paying it back. That's a very steep penalty. That's a lot of money to have to come up with upfront to make a decision in your business that changes things. So that's the penalties. That's the not so bright, fluffy, and exciting side of CUVA. And the full CUVA penalties apply unless a party to the covenant dies or the land is acquired by eminent domain. If you become medically unable to continue the land in its qualifying use, if you actually have a disability and you can't farm anymore, you can provide doctor notices and only 1 year of penalty will be applied, but there still is a penalty. Again, the only way you can get out of the penalty is if somebody dies or the government takes your land. That's it. If the land is taken through foreclosure because you lose your property, you just can't pay for it, 1 year of penalty will be applied in that case too. And these penalties will become a lien on your property. So if you have, let's use that hypothetical of the $21,000 I would have owed if I breached at year 6. If I owe that, that becomes a lien on my property. And if I want to sell my property and move on, that will come out of the sale of that property and go straight to the Department of Revenue. That being said, I think it's also important to keep in mind, if you have a piece of property in Fulton County in the city of Atlanta, and the property values rise so high that you're offered $1 million by a developer, you may be breaching a covenant and that feels like not the right thing to do. But if it's $20,000 coming out of a $1 million offer, that's a conversation to have, to weigh the costs and the benefits and to think about the realities of what you're trying to do, what your bottom line is, and how you're going to move. Just do it with full information, full disclosure. And then the renewal covenants. So if I have a CUVA covenant for 10 years and then I renew it on the same piece of property, there's different penalties for that after year 5. So that's getting into the 15-year range. Stuff happens, and I think that's sort of what the law is kind of touching on. And so there are different penalties after year 5 of a renewal covenant. So here's some more housekeeping details. If you're interested in applying for CUVA, you will apply between January 1st and April 1st-ish. Some tax deadlines have changed in the last couple of years. I don't know if they will continue to change, but that's sort of the time frame and the window to keep an eye out and to start talking to your tax assessors. You can also apply in the appeal window after you receive your assessment notice, and that comes out in the April to June sort of time frame is when you keep an eye out for that assessment notice. And when you get your assessment, if it feels a little too high and you're ready to pull the plug on CUVA, then you can do it during that appeal window after you get your notice. Your application's usually found online. If you do not find a CUVA application for your county, then contact the tax assessor's office for your county. And a small filing fee will be collected when you apply for CUVA to file the covenant, the CUVA covenant, with the title of the land. So if any potential purchasers of the land were to do a title search, they would have access to that public record that it is under a CUVA covenant. And a notary is going to be required for these applications. And most post offices will have a notary available to you. If you live anywhere near a college and they have a registrar, there's generally a notary at the registrar, and also public libraries are a good place to look for a notary around you. And if we have time, I noticed it's a little after 8 already. If we have time, we will actually look at an application together. I have one pulled up and ready to go. They're very straightforward. They follow the statute too. So we'll look at that, but let me get through the rest of this. So I mentioned the agritourism. So if you're selling sodas and such, it's not agritourism, but if you're having people cut down their own Christmas tree and that's what you grow on your farm, that is agritourism. The tax code is what defines agritourism in Georgia. And this agritourism definition, as it's defined in the tax code, is that agritourism means charging admission for persons to visit, view, or participate in the operation of a farm or dairy, or production of farm or dairy products for entertainment or educational purposes, or selling farm or dairy products to persons who visit such farm or dairy. That definition has room to grow. It is vague in some places. It is not vague enough in others. That definition has been the conversation amongst agritourism proponents, agritourism advocates, farmers. The definition is not perfect and nobody claims that it is. So when I used the example of selling soap, I was careful to say selling soap on a farm that is just a produce farm, because I think it's a gray area whether or not you could sell goat's milk soap if you had a goat farm. So I say all this to just bring up the point that if you want to do something and it makes sense in your business model and you're not sure if it falls into this definition of agritourism, it's a great time to sit down with somebody else, maybe some other folks, some other farmers that do something similar, and see how they've been treated with CUVA applying or not, and if anybody said anything or if they've gotten any determinations from the Department of Ag in Georgia or the Department of Revenue, and start these conversations about what are farmers trying to do? What do the statutes say? Is it in line? Is it not? Because this is meant to be of service to farmers and to farm endeavors. So if it's not, it's a conversation worth having. And local tax assessors need education on this. So please, 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 please do not stop at what a local tax assessor says, and do not get frustrated if they don't see that vision that you see or understand your frustration and the limiting definition of agritourism. This is a great space for conversation, for dialogue, and for like really getting clear on what works for agriculture, what works for the tax assessors, and how we can have win-win situations for everyone involved. But there has to be conversation, there has to be education. And as I said, legal representation is a great place for that education. If you are busy farming and you are busy making money, and you know your local tax assessor needs this education, and you know it's going to be important for the movement of local food in general, it may be worth it to go ahead and get representation to have that education piece taken care of for you. And again, if when your business model doesn't fit this definition, it may be worthwhile to address changing the definition and having that conversation with leaders. If you are in breach of your CUVA covenant, you will get a cease and desist notice. And I think this is really important because a lot of business owners are scared of doing something wrong and not ever having any clue that they did something wrong, and then facing penalties or consequences for that. I'm really reassured to see that this is in the statute, because if you are doing something under CUVA that does not fit your covenant, before the penalties are assessed, you will get notice that you are doing something out of line with that covenant. If you're allegedly breaching your covenant, the Board of Tax Assessors will send you a cease and desist letter. and the landowner will have 30 days to remediate the issue. An appeal can be made to the alleged breach. So if they say that you are breaching for selling goat's milk soap on a goat farm, and you think it's worthwhile of an appeal because of that definition of agritourism, if you win that appeal, reasonable attorney's fees and court costs can be paid to you in that instance. All of this, as an attorney, gives me great reassurance that this law really is in place to save farmers money, and it's meant to serve farmers. So if you have something new, have something novel, don't let the black and white of the law scare you away. There is space for exploring those changes. The penalties are steep. I think it would take someone who's very comfortable with risk to take on the possibility of an appeal of a breach to make a point or to set precedent. But it's something to keep in mind that is there. It is an option. I like maybes. I like it depends. And this feels like a maybe situation and it depends situation where there's wiggle room to play with. If you have less than 10 acres of land, and I think this applies to most urban farmers, you can still get CUVA benefits, but you're going to be required by the county tax assessor to submit additional relevant records to prove the bona fide conservation use. They're just asking you, are you really using this property for agriculture use? Are you really a farmer? There are still lots of people that have to wrap their head around the idea of farming on 2 acres or farming on a 1/4 acre of land. Those of us in the local food movement, in sustainable food, know that a 1/4 of an acre can make a huge impact in growing food for our communities, but that's not an automatic for everyone. So the supporting documents include a Schedule E, a Schedule F, farm equipment and farm sales receipts, fertilizer receipts even. And then any other tax or income documentation in general. So if you're farming and CUVA applies to you and you know it, this supporting documentation isn't out of reach. It's something you should have on hand and nearby. Of course, I always say records, 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 records. And I don't know that everyone always keeps records, but those records are important for things like this. And property, so I've mentioned if you're leasing land, your landowner has to be that, qualifying person, but property cannot qualify as bona fide conservation use property if it's leased to someone that would not be entitled to it. So not only does the landowner have to fall under that, the person leasing the land does too. This has interesting immigration implications that have just kind of noticed, and it's interesting. Like, I don't know what that means if someone isn't a citizen yet and they want to lease and farm property under CUVA, but it's important to know that, to keep in mind if you know of anyone who is not already a citizen who is thinking of leasing CUVA property. Again, full disclosure, know that it could become an issue, and it might be something that could not only affect their ability to farm, but could affect their immigration status and all those things. So like, there's a little bit of an orange flag there, just keep in mind. And also keep in mind who owns the farm business, if it's the actual business that's leasing the property, to make sure that the right person is, I hate saying the right person, we're all right people, but under the statute, that the person who is leasing the property is the person who is allowed to be leasing the property under the CUVA statutes. And when you're leasing property and you're thinking, well, why would I even want my landowner to get involved in all this? It's, maybe not that much of a savings. It wouldn't help my rent that much. But it could, one, lessen the fear of your landowners selling to developers if they're under this covenant. So you don't have to worry about them getting an exciting and enticing offer when you're in year 2 of farming, and year 5 of farming is going to be your biggest year. That's when you're finally gonna have your soil the way you want it. You may be able to lower that fear of your landowner selling to developers. And then the cost savings can also be passed down. If there's enough savings, it could lower your rent or lower what you owe for leasing your land. So because property that falls under CUVA has to be used for bona fide agricultural purposes, a property cannot qualify as that if it is subject to a restrictive covenant that would prohibit those things. So these are the same, this is the same list of things that are allowed for bona fide agricultural use. And if there are any restrictive covenants that prohibit those bona fide agricultural uses, the land likely will not qualify for CUVA. So that makes it crucial to know the zoning designations for potential CUVA property. It just so happens that there was a local government and zoning webinar a couple months ago. So if you go to thelawfarm.com, you can access the recordings of these. So if you have a piece of property that you would like, that you're thinking about getting CUVA benefits for, and it's not zoned appropriately, now go through that webinar, get in touch with me. Zoning can change and can be amended to accommodate farming in our community. It's just a bit of a process on the back end. So know the zoning designations and also know that that's a great area. That's a maybe area. That's where I thrive. Okay, so now we're at the point of actually looking at an application, and we will look quickly. If you went to the fultonassessor.org/forms, this is what you would see. And then that second bullet down there, the PT 283A application for agricultural property, is the document. And here's the application. When you pull it up and you open it, I opened it in my preview on my Mac, but you can open it in any PDF. It's fillable as is. I don't think that's because of my Adobe subscription. I think it is fillable no matter whether you have it or not. And you just put in the name of the owner, mailing address, property location. You'll need to look up the land lot, the actual parcel number, the deed, the book page, all of that information you'll need to provide the county assessors. And then you're going to be signing that the information contained as well as the information provided is true and correct, and that the above described property qualifies under the provisions of OCGA section 48.5.7.4. So you're saying, I'm giving you the right information and I know that I qualify. The tax assessors are kind of taking that liability of whether or not you apply off of them, which means you can't use ignorance as an excuse and getting a penalty in CUVA. Before making this decision, I can't stress it enough. Make sure you understand the full breadth of CUVA, make sure it makes sense for your business model, and make sure that you're confident that your property applies for CUVA and will for 10 years. And we go down a little further, again, the map and parcel number. The tax assessor is going to use this and they're going to tell you when your covenant begins, and then it will end on December 31st, 10 years later. And this is part of the questionnaire. Any interest in the land, you're going to list those folks. They're checking for appropriate ownership type. You're going to tell them if it's just an individual or if it's an estate or a trust or a family-owned farm entity. The individual or the family-owned farmed entity are the most straightforward applications for CUVA, but you'll notice there are other ownership types. And then you'll talk about your bona fide uses that apply and a percentage of those use. So raising, harvesting, storing crops, or if it's production of aquaculture, horticulture, or the like. You're going to give them some background information about the property, whether any of it's being leased, other improvements, the restrictive covenants. They're asking a lot of the things that are in this statute, in this application, and bringing it up to the surface for you to answer yes or no and to see those requirements. Is there any type of business operated on the property? If yes, explain. And then a signature. So the application is fairly easy, the actual application. It's the knowing exactly what CUVA entails and knowing that it's the right fit for you that really takes the most work and time on the back end. Are there questions about CUVA generally? Because I think now my slides are moving into the information that was shared to me from another farmer about tax assessments generally. Any questions?
Michelle, who establishes the soil designation?
That's a good question. I've actually had a really hard time finding who's actually going to do that. I think that's something you could work with the tax assessors. It sounds like they may do it themselves. And of course, it's always open for appeal if they give you a soil designation that you think doesn't fit. I know that the extensions, the county extension offices all provide some sort of soil testing. So you can, of course, do your own soil testing to compare to what the tax assessors come up with.
So you don't know if there's a standard where the extension service, can tell you what kind of soil it is, but do they grade it or I mean, the tax assessor wouldn't seem to be, particularly Fulton County, as you mentioned.
Sure.
He lives on a farm, but I bet he doesn't know a lot about it.
No, and they do have CUVA assessors who are more informed, who can help with that grading. It seems, and there's allusion to a table somewhere that breaks down the different soil designations and what that means. I have not found it yet. Something I could dive deeper and find if a client needed, for sure. I just haven't found it yet, but I know it exists and is out there somewhere.
Okay. And second question, I assume that, if you had a larger tract outside Fulton County, and I mean, let's just say 25 acres and you had a homestead on 2 acres, and I'm assuming you could subdivide the land in as many ways as you wanted to, where CUVA may be applicable, say in 15 acres of it, but then you could walk somebody across the property line to the next tract to sell them that hot chocolate?
Yes. If you know that one of those breach activities is a part of your business plan and you have that much acreage, it's absolutely plausible to just kind of set the 5 to 10 acres aside that you're selling hot chocolate on, you're doing camps, set that aside, and then get the conservation use benefits on the rest of the property. That's
okay.
Doable. Yes.
Thank you.
You're welcome. And you can switch between types of conservation use during the covenant too. So if you wanted to get a timber conservation use, or I don't know about wetland, let me not go there. If you were in timber and you wanted to switch to agricultural use and then back again, you can do that once or twice during the covenant. There's special rules about that, but you can switch between conservation types. And also between that agricultural preferential assessment and CUVA, that can be switched in 10 years too.
But when you've got fields in fallow, you can't make money off of them doing anything else.
Not that year. Yes. Yes.
Okay.
Yes.
So I had couple questions I had jotted down. One of them was, so I know talk about breaching the contract, and I was just curious, who actually enforces and or investigates those kinds of things?
So that's the county tax assessor who's actually enforcing and who's going to let you know if you're in breach and send you that cease and desist notice. When it goes beyond the tax assessor, let's say you're appealing, they're saying you're in breach and you're appealing that, it may move into the Board of Assessors at a higher level, and eventually you'll go to Superior Court if you are appealing. It will move beyond that office at certain points in appeal, but it starts with the county tax assessors.
Gotcha. And then when you mentioned if there was a breach and you appeal and you may be able to recover the costs and the fees, I was just kind of curious, like what kind of scenario is that where you're able to recover the cost and the fees? Is it because of like legal representation, or is there some other kind of silver bullet there?
It's to give the landowner the agency to be able to say, I'm not in breach, my tax assessor is wrong. And if they do show that, if they go all the way to Superior Court and they do show the tax assessor was wrong, it's just the government's way of saying like, whoops, we're sorry. And now you had to pay those attorney fees. We'll take care of that for you. Does that make sense?
Yeah. Government being accountable.
Exactly. So if you win your case, if I say I'm not breaching and I take it all the way to Superior Court and I lose, then I've lost the case and I've lost the resources in getting there. But if I take it to Superior Court and the judge says, yeah, I see their point, they weren't in breach, I think it's a wonderful thing to know that that taxpayer can then get those court costs and attorney's fees paid, for sure. And as an attorney, I think it's important because I'm not going to advise somebody to appeal a case as readily unless it seems like it is very much is direct and straightforward. So, you can have that reward at the end if you know it makes sense. And in these agricultural spaces, I think it's an important thing to investigate sometimes. Like there's a lot that isn't understood about sustainable farming and the business models and the way it's run. So I could see where that could really come into play for a farmer, for a modern day farmer, for sure.
All right, I've got two more. So, in that definition of agritourism, which I know you mentioned is that's the Georgia definition of agritourism. So it almost sounds like volunteer groups may fall under agritourism by that definition.
Volunteer groups. Oh, that is an interesting thing in and of itself. You may need to come back next month to the employment webinar. So technically a for-profit farm can't have volunteers. Like that's just a fair labor standards sort of issue in general. But those volunteers could very well be doing agritourism thing. Call them agritourists, not volunteers. I'm getting somewhere with this, Jim. Yes, if you're having somebody come learn how to spread compost, that could fall under agritourism, absolutely.
Wow, okay. Yeah,
I think.
Reading it sounds like it to me, but I'd love to hear it. And then my last question that I jotted down, and you may have covered this. So, the CUVA assessment lasts for 10 years, right? Mm-hmm. So then what? What happens after 10 years?
You get a CUVA renewal.
Okay, so you did say that. Okay.
Mm-hmm. Gotcha. Yeah, absolutely. And I don't think there's a limit to the renewals. I didn't come across anything that suggested that. So you just continue the renewal. The slide that I just ended on, what if something comes up? If you are in the middle of a CUVA and you sell your property to someone else who applies to CUVA, it's possible to sell your property and to transfer that over to the next owner too. That's a point I didn't make and you didn't ask, but I told you, you're welcome. Did I answer I answered the question about renewal.
Yeah.
And anytime there's a change, I think even in renewal, it behooves the person renewing to then, back up again and say, well, what is the renewal CUVA? What does it entail? The penalties are a little bit different, like I said, after year 5 of a renewal. So anytime something changes with CUVA, back up, look to the statutes and regulations for the governing language. Don't assume the tax assessors are knowledgeable about every CUVA nuance. They just aren't. They do lots of things. Be kind, be generous to them of what they do, but don't make the assumption that they know best and that you're wrong if they tell you a no. Consult with an attorney. I'm here. And hire legal representation if you feel overwhelmed or start doubting yourself in any way with this CUVA stuff. Or anything. Maybe not anything.
How about getting the crops out of the field? Is that something you should consult?
See, that's the anything I didn't mean. But, I'm the kind of attorney that might come help you get crops out of the ground, but that's a whole separate thing. But yeah, in any of these CUVA issues, any agreement generally, consult with an attorney. Use a team of professionals to support you. Oh, it is 8:30, so you are welcome to head out. That was the CUVA information. I'm going to share other property tax assessment issues using the Georgia case study, a Georgia farmer in Middle Georgia who had this issue. I will tell her story at a very hearable, lightning speed pace. Y'all ready? These are her takeaways directly from the farmer's mouth. Tax code is written broadly concerning agriculture, and the lawmakers aren't necessarily farmers, period. Taking on local government issues takes time and persistence. Pay attention to notices your farm business receives and understand the consequences for not doing so. Keep in mind these exemptions are available because there's an intention to save farmers money in operations. Hold assessors to this intention. And in conversations and negotiations, convince yourself you're right and stick to it. And in pursuing a local tax issue, you may be setting precedent. It's not just about you, it's about local ag. And it's more than just a couple $100 a year. It can be a larger precedent. Those are her takeaways, and I'll tell you her story very quickly. She received a tax bill. This was what came in the fall. This is not what comes to put you on notice of what your taxes are in the summer. She received a tax bill and it seemed high. Her bill included taxation of 4 high tunnel structures, which to her and in common sense is not real property, and which fell into the category of exempt property for agricultural operations, a separate statute that I didn't get into tonight. But property for agricultural operations, I mentioned it briefly, like the tractor, isn't taxed the same way that other property is, like your boat might be. So she had these high tunnel structures, and the county had called them real property. They were assuming it was a permanent structure. They were assuming it was a building on her land, and it was being assessed as such. She didn't want to pay that amount for it. She knows that these are things that you can take down. They're movable. They're not real property. Her local tax assessor's office was dismissive, even when she clearly cited Georgia code. She was told it was too late to appeal the amount, and the burden fell on her to prove that she never received the notice. That was another issue in her story. But the nuance is so important to remember that not everything happens administratively as it should. Don't give up just because somebody says, no, you're wrong, no, you're late. Very often you're right, something may have happened. So don't give up. She was told it was too late to appeal. The tax assessor's office, she was giving them the citations for the exempt property for agricultural operations. They dismissed her. She navigated her local system, figured out the moving parts, and went to 4 board of assessors meetings, at least 4, putting herself on the agenda. which is a very savvy, nuanced thing on her behalf. She figured out how these meetings ran and what she needed to do to put herself on the agenda. I would not expect every person to be able to figure that out confidently and straightforwardly. She contacted the Georgia Department of Ag, the Georgia Department of Revenue, and her county commissioner. They were all supportive of her perspective and her points on this. They all backed her, but there really wasn't anything they could do to overstep the Board of Assessors in this case. So she kept going to them, going to those meetings, and finally, her Board of Assessors made a motion to distinguish high tunnels and hoop houses from greenhouses, which would be real property, which are permanent structures. So they made a motion to distinguish those two, and she got the savings that she was looking for. The motion solved her issue, but there's still a larger piece of not understanding the structures themselves, of not knowing the difference between a greenhouse and a high tunnel. And now there's confusing precedent set. Like, she spent over a year on this issue, and it's still not completely straightforward for farmers with high tunnels versus greenhouses. Just that piece is clear there, but there's not that complete education piece or complete understanding. It took over a year to settle and resulted in a savings of about $500 for the tax year. But she thought it was important enough to keep pursuing for multiple reasons. First of all, $500 in 1 year may not seem like much, but over 10 years, it adds up to $5,000. Again, that's retirement savings that can make a huge difference in the long run. If she added more high tunnels without resolving the issue, so if she had just let it go and said, well, it's just 500, I'll manage, I'll make it. If she wanted more high tunnels in the future, her taxes would continue to increase. And also, she understood the intent behind the agricultural exemptions, and it was important for her to pursue that intention, that farmers should not be paying extra taxes on their property, on their real property, and on their machinery and operation property. She understood that. She wanted to set that precedent, and she did. So again, that was just about hoop high tunnels versus greenhouses and having to make that distinction at the tax assessor's office. Don't assume that what you're being asked to pay is what you have to pay. Question everything, and especially these tax assessments. Make sure you understand where they're coming from and hold your assessors accountable. So the takeaways from tonight are that Georgia law provides multiple outlets for farmers to save on taxes, including property taxes. CUVA provides the greatest cost savings for your property tax. It lasts 10 years, and it comes with the steepest penalties of all of these tax benefits. Paying close attention to taxes and understanding where the amounts come from is a must for every farm business. And tax assessors and legislators are not necessarily farmers, and they're especially not likely to be small-scale sustainable farmers. Some of these issues require education and precedence and patience. If you have more questions, and I hope you do, that was a lot of information at once, sign up for office hours, calendly.com/thelawfarm/office hours. If your farm operations in Clayton, Cobb, DeKalb, Fulton, or Gwinnett counties, these office hours are completely free thanks to the generous support of Foodwell Alliance. If you're outside these counties, I'm offering these office hours to webinar participants for $75, which is a huge discount from the usual $250 fee for a working consultation. If you have any questions leading up to an office hour, feel free to email me, michelle@thelawfarm.com. But please, the office hours are available to you. Use them. Are there any final questions this evening, gentlemen?
Michelle, yeah, I was thinking the purpose of the conservation was looking at the larger land conservation opportunities available through NRCS and organizations like the Athens Land Trust and so forth. That's another conversation for another day, but let's say you did get a conservation track worked out with one of these other parties, and what they do is you put a permanent covenant on your property for lifetime, or for into perpetuity, and you get some benefit depending on who you do that with. It may be an annual payment by the NRCS, or it could be like a large tax deduction one time for the difference between, the conserved use versus if you were to develop it. If you had taken that option, is it safe to assume you would still qualify for CUVA?
I am not sure. I have not dove into that nuance yet of getting those federal benefits and other benefits in addition to CUVA. I would think there's nothing stopping you from getting benefits on the levels that they're available for keeping your property in a wetland conservation state, in a soil conservation state, and all those conservations. I don't foresee any reason why you couldn't get all the benefits, but I also haven't seen anything that straightforward says that you can. I'm not sure.
Well, it's different taxing jurisdictions, which would make me presume you would, because this is a county local tax versus this may be a federal or a not-for-profit conservation arrangement.
Right.
My other question just is there any authoritative source on this case you described where the greenhouses versus the tall tunnels? What about sheds? What about grain bins? I mean, is there an authority that defines this in the code or otherwise?
So there's not an authority that defines it in the code. And I'm not certain that there is a lot of case law, since these are dealt with on the very local tax assessor county level. Often those sorts of issues, if you have a question about a shed, there likely will not be precedent, and it will be a matter of pursuing and getting that clarification. These local issues like this, and I think on the county level, a tax assessor county level, I think of that as very local. Often there isn't a lot of precedent, so you may be setting it for an issue, very likely.
Okay.
Yeah. I was just going to add to that. So I work with the city of Atlanta, and I would say that for us, when it comes to these kinds of questions, zoning is actually where we start. So in our zoning code is where it actually talks about structures, chicken houses, high tunnels, other kinds of tool sheds, etc. So I'm sure there is at the county level too, but I would even say start in that local, hyper local kind of city or town level, because I know in city of Atlanta, zoning is actually where you can get some of those answers, which doesn't always match up then to county, state, or federal definition, but just also a start.
Jayla, I'm glad you said that. And I want to point out that the city of Atlanta is actually very ahead of other municipalities and other counties and local jurisdictions in Georgia in terms of understanding local sustainable ag and seeing a bigger picture. I think city of Atlanta does a great job of knowing what farmers are doing and accommodating for that. So there probably is more in the zoning code to begin with. And bravo, city of Atlanta. There's just a little clap for you guys. But not every other city, not every other county is even going to have hoop houses and high tunnels mentioned in the code. But hold them to it, have them mention it, become that precedent. I think local government is a great place to feel democracy.
Cool.
Yeah.
Well, I didn't have any final questions, Michelle, but I just wanted to say that this was great and super informative. I just joined the call because I saw that this was an interesting topic and something I figured I could use at my office and at my work and all that stuff. And this was super informative. And also, it was nice to meet you as well, Charles. So just keep it up. And I'm going to make sure I spread the word for people to attend some of your future end of the year seminars as well. But this was great.
Great. Thank you. I'm so glad you made it out tonight.
I would echo that to both parties. Thank you.
Oh, you have a tractor emoji on your.
That's good. That's good stuff, Charles. That's good stuff. I knew you were ready, Charles. I'm like, Charles is ready. He's got it good.
Oh, thank you both so much for coming out tonight. Thank you. And follow up with office hours if you need it.
Okay. Ciao.
Sounds good. Y'all have a good one.
Good night.